The Four Boxes Diner reports, and you decide, have we just uncovered some critical information in the United States Court of Appeals for the Third Circuit out of Delaware, Pennsylvania, and New Jersey as to whether or not there is a secret supporter of the Second Amendment among the Biden and Obama judges currently sitting on that court? I'll give you the evidence, and let me see what you have to say about what we reveal in a moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so we've uncovered something very interesting and potentially very good news when it comes to our Second Amendment right to keep and bear arms in the United States Court of Appeals for the Third Circuit. Just to jog your memory, the U.S. Court of Appeals for the Third Circuit is the federal appellate court that oversees Delaware, Pennsylvania, and New Jersey, anti-gun New Jersey. So, as you may recall from earlier this week, I reported the unprecedented, shocking, and fantastic news that after an oral argument on July 1st, 2025, in front of a terrible 3-judge panel where we're going to lose 2-1 on the so-called issue, or the issue of so-called assault weapons, which are just semi-automatic rifles and magazines that hold more than 10 rounds in New Jersey. I reported that after that July 1st oral argument, which went poorly for the Second Amendment cause, that's clear, that just this week, the U.S. Court of Appeals for the Third Circuit announced sua sponte. And sua sponte is just a Latin phrase for basically doing it on your own, meaning the court just did it on its own initiative. Nobody asked it to do this. At least no party asked it. And sure enough, the Third Circuit sua sponte entered an order rescheduling oral argument for October 15th, I believe, 2025, in front of the entire Third Circuit Court of Appeals, which is over a dozen judges. We'll get to that in a moment. Now, this is a great big bit of news, folks, and great news for the Second Amendment, because we were undeniably going to lose that 2-1 panel, or that 3-0 panel. I think it was going to be 2-1. I think Judge Smith, we'll get to in a second, would have voted for us, but who knows? But either way, that panel was going to rule against the Second Amendment and in favor of upholding the so-called assault weapon ban and magazine capacity ban in New Jersey. But that opinion was never issued because the Third Circuit has decided to en banc this case, which means the whole Third Circuit will hear the argument on October 15th and make a decision as an entire circuit. And this was very good news, in addition to the fact that obviously we're going to lose the case, and now maybe we're going to win the case. And the only reason why you would sort of take an opinion away from a panel, in my view, is if you think the panel was going to get it wrong. Otherwise, you just let the panel issue its decision, and it would be what it is. It's just, you wouldn't interfere. It is what it is. The panel came out against the Second Amendment, and the court agreed with it, so they just let it stand. Why interfere? But the fact that the entire Third Circuit stepped into this breach and intercepted that draft opinion almost certainly that was going to go against the Second Amendment tells me that the en banc Third Circuit is going to view the Second Amendment issue much more favorably in favor of freedoms, our rights, and our right to keep and bear arms. Now, what I've uncovered is quite interesting. Here's what I've uncovered. I want to see what you think about it. If you read the Court of Appeals for the Third Circuit's internal operating procedures, which I'm sure you're all familiar with the internal operating procedures of the Third Circuit. I mean, who doesn't read those on a frequent daily basis, right? Who doesn't like to go to sleep with an audiobook talking about the internal operating procedures of the Third Circuit? I know I do. And because of that, I uncover the following statement. And then we're going to talk about why this is very interesting. In those procedures, it reads as follows, quote, "If during the circulation of draft opinions, a majority of the active judges on the Third Circuit who are not disqualified votes that this case be considered en banc the chief judge enters an order for a rehearing en banc. Okay, this is a very big deal, and why is that? It says that when an opinion that's been drafted by a panel is circulated to the entire Third Circuit, which is their internal operating procedure. So a 3-judge panel writes in a draft opinion, they circulate it to all the judges in the Third Circuit, and if the majority, listen carefully, the majority of the active judges on the Third Circuit, if they vote to hear the case en banc, then the case will be heard en banc, and that draft opinion by that 3-judge panel will not be released. Now, why am I hammering home on the phrase in this internal operating procedures of the Third Circuit about the majority of the active judges on the Third Circuit? Because right now, remember, Emile Bove is not on the Third Circuit technically yet. He has not been sworn in. And we have a pending nominee, Jennifer Mascott, who has not been confirmed by the Senate. So take them off the table. They're not relevant for this right now. There are 12 active judges that would have reviewed this draft opinion. 12 active judges on the Third Circuit. 6 of those were nominated and confirmed by presidents of the United States who were Republicans. 6 of those individuals, those judges, were nominated and confirmed by presidents of the United States who were Democrats, which means that you had 6 Republican active judges and 6 Democrat active judges. So if you're 6-6, that's evenly split. That's a tie. And if it's a tie, what does that mean, folks? It means that you would not have had a majority of the active judges on the Third Circuit to vote to hear the assault weapon ban and the large capacity magazine ban case out of New Jersey en banc. Because it would have been split 6-6, evenly tied, evenly split. A tie. Tie goes to the runner, as they say. In this case, tie goes to letting the panel issue its decisions. But that didn't occur because that means the majority of the active judges voted to hear this case en banc because they were not satisfied with what the panel was going to say about the Second Amendment, which almost certainly was going to be ruling against the Second Amendment. Which means that some Democratic nominated judge, either one of the Biden judges or the Obama judges, had to have voted with the Republicans to hear this case en banc, this case of Association of New Jersey Rifle and Pistol Clubs and Cheeseman, I believe, against the Attorney General of New Jersey. Now, just to show you my work, here's a list of the 12 active judges that would have had an opportunity to vote on whether or not to hear this assault weapon ban case en banc once that opinion by the panel was circulated. Here's the list. And if you look at that list, the first 6 are the Republican-nominated judges. Chief Judge Michael Chigueras, W. Bush appointee Thomas Hardiman, Trump appointee Stefanos Bibos, David Porter from Trump, Paul Mandy from Trump, Peter Phipps from Trump. Those are the 6 Republican nominees. But then you have the 6 Democratic nominees. Ariana Freeman, Tamika Montgomery Reeves, a Biden appointee, Cindy Chung, Biden, Patty Schwartz, an Obama judge, Cheryl Krause, Obama, Philippe Restrepo, Obama. You see, that's 6-6. Those are the active judges as of this moment in time. Now, that means one of those, assuming that all the Republican nominees voted to hear this case en banc, no guarantee of that, we don't know. But assuming that were to be the case, one of the Biden or the Obama judges would also have to vote it here en banc because they were dissatisfied with the panel decision that was being circulated internally. So there must be someone that's a Democrat, is my guess, best speculation, wanted to hear this case en banc. Very interesting. Now, I should also mention there's 3 other variables here. In addition to the 12 judges I just pointed, those 12 judges would have voted as to whether or not to hear the case en banc. But there's 3 other judges to consider, in addition to those 12 judges, when this case is argued on October 15th. And this is sort of important. The first is Judge D. Brooks Smith, excellent judge, been on the bench a long time. He is technically a senior judge, which means that, but because he was on the 3-judge panel for the oral argument on July 1st of 2025, Judge Smith gets to sit on the en banc panel on October 15th because he was part of the original panel. So even though Judge D. Brooks Smith is a senior judge and thus is not an active member of the Third Circuit and would not be able to vote in en banc cases as a general matter, he gets to vote in the en banc case here because he was on the panel from which the en banc decision arose. So Judge D. Brooks Smith, who's a senior judge, I think he was appointed by George H.W. Bush, by the way, very respected judge, is going to be on that en banc panel on October 15th. And I don't think that's a bad thing for the Second Amendment, by the way. But then there's 2 additional variables. As you know, Donald Trump appointed to the federal bench Emile Bove. The liberals freak out about that. But he has not been sworn in yet. Presumably, I don't know this for a fact, but presumably he is cleaning up some of his final items he had to do at the Department of Justice before he's sworn in as a judge. Because once he's sworn in as a federal judge under Article 3 of the U.S. Constitution, he's not going to be able to work for the executive branch anymore. So I suspect he's wrapping up business at the executive branch at DOJ right now. And once he's done wrapping up whatever work he's working on, he will be sworn in and sit on the Third Circuit. I'm guessing he will be on that en banc panel as an active judge of the Third Circuit on October 15th. Now, there's one other really important item, and we're going to have to reach out and touch some people in the government probably on this topic. We're going to have to kind of maybe communicate on social media with some op-eds and some articles, whatever, on this following point, and that's this. There is a recent nominee to the U.S. Court of Appeals for the Third Circuit, Jennifer Mascott. She's excellent, very good law professor and lawyer. I think she clerked for Clarence Thomas. I think she also clerked for then Judge Brett Kavanaugh before going to clerk for Justice Clarence Thomas, I believe. But she clerked for the Supreme Court. I think it was Thomas. Nevertheless, Jennifer Mascott has just been nominated recently by Donald Trump. Now, the reason why this is important is if she is confirmed before October 15th, Trump appointee Jennifer Mascott would be able to sit, presumably, on that en banc panel on October 15th and would be able to vote on the case and rule on that case. However, if the United States Senate, which is not moving super fast for a bunch of reasons, but there's no reason not to move fast on this one. The U.S. Senate needs to move fast, in my opinion, on getting Jennifer Mascott confirmed in the next 4 to 5 weeks. If the Senate gets her out of the Senate Judiciary Committee with a floor vote on the U.S. Senate floor, and she's confirmed, she will get to sit on October 15th. If the United States Senate sits on its dupa too long, well, then putative judge, she's not a judge now, but putative judge, Jennifer Mascott will not be able to participate in that October 15th oral argument or make a decision on that case en banc because she won't be a judge yet. She won't be on the court yet. So to me, if it were me waving a magic wand, I would want to wave a magic wand and get Jennifer Mascott on that court ASAP. In fact, I think you can make a strong case right now that there is no more important federal judge appointment pending that needs to be expedited, that needs to be pushed through as soon as we can, than Judge Jennifer Mascott, for no other reason than to make sure she's on the bench for that October 15, 2025 oral argument in this case of Association of New Jersey Rifle and Pistol Clubs and Cheeseman, to deal with whether or not the New Jersey assault weapon ban in air quotes, and large capacity magazine, ban, again, large capacity magazine in air quotes, whether or not that law is constitutional under the Second Amendment. I think it would be very helpful to have Judge Jennifer Mascott on the Third Circuit hearing that case. It'd be very good for the Second Amendment. Can we get the U.S. Senate to act fast? I don't know, but that is what should happen in my view. So anyway, hope you enjoyed today's episode. This is all great news, but I wanted to give you some inside details that some Democratic nominee almost certainly voted to hear this case en banc. I take that as a further good sign that maybe, just maybe, the Third Circuit is going to respect the Second Amendment in a way other courts have not. And I think that's quite likely because the Third Circuit did a very good job in the Brian Range case dealing with nonviolent felons, a decision that was so well written by Judge Thomas Hardiman that the United States, the Department of Justice under Donald Trump did not even seek cert to the Supreme Court. They just rolled over and conceded the point, as well they should. And Brian Range presumably is fully able to keep and bear arms despite his 30-year-old conviction for some food stamp issue for a couple $100, which was nonviolent, obviously. So there you have it. Hope you enjoyed today's episode. Make sure you follow me at X at @4boxesdiner. And don't forget to subscribe both to YouTube and to Rumble and like this video. I'll talk to you real soon here at the 4 Boxes Diner.
Orders up. Table 2A.